Hey guys, I am Devi and welcome back to Devi's Law Capsule. In this video, we will be discussing about natural justice principle. The principle of natural justice originated from common law in England and it is derived from the expression jus natural of Roman law. Jus natural means law of nature. That is, it is a system of law which is based on the fundamental principles of right and wrong. Natural justice principles are one of the procedural rules for the administrative action and these principles are closely related to moral principles. Another thing is that natural justice principles are not codified laws but they are judge-made laws. Natural justice principles controls all actions of public authorities by applying rules relating to reasonableness, good faith, equity and good conscience. In Maneka Gandhi versus Union of India in the year 1979, the court held that natural justice principle is a humanistic theory which means to impose fairness in law. In A.K. Roy's case, Justice Ramaswamy observed that the rules of natural justice are not embodied rules and they cannot be imprisoned within stringent jacket of rigid formula. Next is that the natural justice principle is a branch of public law and it is also known in different names like substantial justice, fundamental justice, ethical justice, and Justice Bhagavati has defined natural justice principle as fair play in action. The golden motto of natural justice principle is to secure justice and to prevent miscarriage of justice. And these 2 points were raised in A.K. Kraipak versus Union of India. The non-compliance of natural justice principle leads to arbitrariness and violation of Article 14 of the Constitution. Next is that the principle of natural justice recognizes 2 important principles. First is rule against bias and second is Audi Alteram Partem. Now let's see these 2 principles in detail. Rule against bias is based on a legal maxim that is nemo debet ex judex in propria causa, which means that no man shall be a judge in his own cause. Here, the term judge is not confined to judges of the court, but also it includes all adjudicating authorities. An important case is R versus Sussex Justice ex parte McCarthy. In this case, the court held that justice should not only be done, but it should be seems to be done. Next is that the rule against bias may be classified under the following categories. First is pecuniary bias, second is personal bias, and third one is subject matter bias. In the case of pecuniary bias arises when the adjudicating authority or judge has any monetary or economic interest in the subject matter of the dispute or case. Second is about personal bias. Personal bias arises from near and dear, that is from friendship, blood relationship or relationship through marriage. And third one is subject matter bias. Subject matter bias arises when the adjudicating authority or judge has any general interest in the subject matter of the dispute. One of the important case under pecuniary bias is J. Mohapatra versus State of Orissa. In this case, the Supreme Court squashed the decision of textbook selection committee because some of its members were also authors of books which were considered for selection. So in short, the principle of rule against bias makes it clear that the deciding authority must be free from bias and should deliver pure and impartial justice. So these are some of the important points that is coming under rule against bias. Moving on to the second fundamental principle of natural justice, that is Audi Alteram Partem, which means that no man should be contemned unheard, or both the sides must be heard before passing any order. And the main object of this principle is to see that an illegal action or decision does not take place. And this point was raised in Balco Employees Union versus Union of India in the year 2002. Moving on to the essentials of Audi Alteram Partem principle. First is notice and second is fair hearing. The first and the foremost ingredient of Audi Alteram Partem is notice. The term notice is derived from a Latin term notatia, which means being heard. So there is a duty on the part of the deciding authority to give notice to the concerned person. The term notice should contain certain elements like time, place and nature of hearing. Second one, legal authorities under which hearing is to be held, and third one, statement of specific charges. So these are some of the points that the notice should contain. Next is an important case, that is Cooper versus Wandsworth Board of Workers in the year 1863. In this case, the court held that any order passed without giving notice is against the principle of natural justice and is void ab initio. Another important case is R versus University of Cambridge in the year 1723. This case was popularly known as Dr. Bentley's case. In this case, the university authorities, without giving notice, cancelled the degree of Dr. Bentley on the ground of misconduct. The second fundamental principle of Audi Alteram Partem is fair hearing. That is, the person concerned must be given an opportunity of being heard before any adverse action is taken against him. Some of the essential ingredients of fair hearing is that first one, authority to receive all relevant evidences from both the parties. Second, to disclose such evidence. Third one, to provide opportunity to rebut the evidence. The term rebut means to raise objection to such evidence. Next is about different stages of fair hearing. First is right to present the case. Second one, right to know evidence of the other party. Third one, right to representation through counsel. And fourth one, speaking orders. So first one is right to present the case. That is, the adjudicating authority must give reasonable opportunity to both parties to effectively present their case and evidence. Second point is right to know evidence of other party. That is, the affected party has the right to know evidence on which the action is proposed to be taken against him by the inquiring authority. Third point is right to representation through counsel. Actually, the right of representation through counsel or advocate is not considered as a part of natural justice principle, and it cannot be claimed as a matter of right. When the case involves a question of law or the parties is totally illiterate, an opportunity to present their case through counsel is permitted. Fourth point is speaking orders, or orders speak for itself. That is, sufficient reason should be given in a judgment. So, these are the different stages of fair hearing. These are some of the important points that comes under Audi Alteram Partem principle. With this, we came to the end of this topic and hope you guys benefit from it. And if you find this video useful, please do like, share, subscribe and also press the bell icon for more updates. Thank you.